our very last speaker of the evening, Angharad Price. Angharad is an employed barrister who currently works for the Equality and Human Rights Commission, as you've all heard from other speakers this evening. She was called to the bar at Middle Temple in July of 2004. We actually did the bar course together here in Cardiff. After working as an advocate in civil litigation and in private practice as an employment solicitor, she has been a public sector lawyer for over 10 years, with time at Caerphilly Council, Cardiff Council, Welsh Government, and then finally with the Commission. In 2013, she was awarded a merit for her LLM in legal practice by Cardiff University after writing her dissertation on disability discrimination and reasonable adjustments. So over to you, Angharad.
Thank you, Mona. I think we were actually called together, so you probably remember the date. I've given myself slightly longer to talk because I'm going to be talking to you about the Commission and our legal work and how to help, what Asana mentioned, OASIS extending, how the Commission with our legal work can support lawyers who are working on discrimination and human rights cases. But I'll try and be as brief and quick as possible, so perhaps Rachel can tell us more about her second case, which I'm sure she's kept us on the hook for now. So I just want to start by reminding you, I'm sure most of you, by coming to today's event, are aware of what the Equality and Human Rights Commission are. Sorry, we say it very quickly, so I'm going to try and slow it down. But we are a catalyst for change. So tonight is an example of how we bring people together to devise solutions. We enable and encourage improvement in this area and look to build capacity in organisations to help people affect change for equality and human rights. We're also an information provider, helping people understand their rights and improve compliance with the law. We're an influencer, and we use our evidence and legal expertise to influence public policy and to inform debates. We're also an evaluator and enforcer, using our strategic enforcement powers selectively to protect people against serious and systemic abuses. As most of you probably know, we were set up in 2007, bringing together all those separate strands and previous legislation that used to deal with each protected characteristic on its own. We're an independent statutory body. We're funded by the UK government, but we're a non-government department body. So we have independence, although we're a statutory body. And we are the regulator for the Equality Act, as well as an A-grade human rights institution. A-grade because we are given that grading by the UN, and we report to them on human rights and how the UK and Wales are faring in terms of the UN conventions. We have a statutory duty to monitor progress in society on equality and human rights, and our Is Wales Fairer Report 2018 is a comprehensive review of evidence from across all areas of life in Wales. It includes recommendations to government, public and private sector organisations to address key findings. And it's a shared resource which should be used by anyone that wants to set priorities for equality and human rights, and is used to inform the Commission's latest strategic plan. I'm going to talk to you a bit about our legal powers and our legal work. His Honour went through in detail the Equality Act 2010, and that obviously informs large parts of our work, but we gain our powers from the Equality Act 2006. So I'm going to go through some of those in detail in a moment, but those are Section 28, which is our power to provide legal assistance. You may have heard of that. We provide funding and legal support projects under that section. Section 30, which is our power to bring, intervene in or support judicial reviews. Section 24, which is our power to apply for injunctions. And Section 16, which is our power to undertake inquiries. Section 2021, which is our power in relation to investigations or unlawful act notices. And Section 31 and 32, which specifically relate to the public sector equality duty assessments and compliance notices. I'm going to talk to you a bit more about when we've used those, so you can sort of understand how they work in practice. But I'm going to do that under three different headings, really. So the first is about how you can use work that we publish as evidence and source of information for cases. Secondly, how we might fund or support cases that you're involved in. And then lastly, something we've recently had research undertaken in relation to our legal work, which is about follow-up work and our unique legal action powers. So starting off with Section 16 inquiries. So we undertake inquiries under our strategic aim and areas of our work. So for example, at the moment we've got a current inquiry into disabled people's experience in the criminal justice system, and that's due to be published next month. It's a legal inquiry into whether people with mental health conditions, cognitive impairments and neurodiverse conditions, including autism and ADHD, are experiencing discrimination and being put at risk of miscarriage of justice due to lack of support in the criminal justice system. And one of the key areas under that inquiry is about video link hearings and also the effects of court modernisation, which I'm sure you'll all be aware of in terms of court closures in Wales and those impacts upon people accessing, and in particular disabled people with those conditions accessing the criminal justice system. One of our previous inquiries related to disability-related harassment, and that report is already available on our website. That looked at the progress public bodies are making in relation to preventing and dealing with disability-related harassment. And our final report revealed that hundreds of thousands of disabled people regularly experience violence and bullying, much of which is going unrecognised by public authorities. So that's two examples of our inquiries, which could be used perhaps if you have any cases in those areas, because they contain substantial evidence that support their recommendations and conclusions. One of the other areas that could support evidence is Section 21, our investigations. So, for example, in June 2019, we carried out an investigation into a care agency that was using pre-employment health questionnaires. We sort of deliberately this evening avoided having employment law speakers, although that's my background, but that's such a common area in terms of discrimination. We deliberately tonight picked speakers about public sector cases and housing cases rather than employment cases to give you a more broad range and encourage you in terms of OASIS extending in areas that aren't often featured in discrimination legal events. But that investigation dealt with the care agency Elite Care Plus, and after receiving evidence it was asking pre-employment health questionnaires during its recruitment and registration processes. We launched an investigation to collect evidence to substantiate that allegation and to challenge the discrimination so that everyone had the right and we could use the evidence from that in our work in terms of pre-employment health questionnaires. Lastly, under evidence, I'd just like to highlight the other work the Commission does. Our website, as you know, contains our codes of practice and guidance, but also we've recently launched the Human Rights Tracker, which is an invaluable resource for lawyers and others, and details more information in relation to the UN Convention and all the various reports the Commission and others have submitted to the various committees in relation to international equality and human rights law. And also Equinet, which the Commission regularly reports into, which is the European Network of Equality Bodies. And again, their website, and I have links to those to send to you all afterwards, but their website contains useful resources, which including reports. For example, I looked at one recently on a case I'm working on which relates to positive action measures. So all of the equality bodies across Europe have reported in on the positive action measures in their country, and you can view those reports for free on that resource. Another one we recently reported into only yesterday was about access at polling stations for voting, for example. So it's an invaluable resource if you were bringing a discrimination claim, both of those, the treaty tracker in terms of the UN conventions and also Equinet, other work of equality bodies across Europe. There's almost no topic described under the Equality Act that isn't also covered in those two resources. We also publish and complete consultation responses. For example, we did a response to the Civil Justice Council consultation on vulnerable witnesses and parties within civil proceedings. We respond and produce parliamentary and assembly briefings. For example, we produced a briefing to the House of Lords debate on increasing the social value of public procurement last year. And we give evidence to the Equality Act and Disability Committee in Parliament, and our responses to those are published on our website as well. And again, they contain invaluable evidence the Commission has collected for you to use to support cases. Moving on then to the second point I raised, which is funding or support for legal cases. Most lawyers hopefully know that the Commission supports and provides funding for strategic cases. So our litigation and enforcement policy is on our website. Again, it details that we support strategic cases and under those connected to our strategic plan. But just to give you some examples, so there was a case in 2019, Smales and Cleaver Court residents, I think His Honour was the judge in that case, and Keris was the counsel in that case. So I'm glad they haven't stolen my thunder by bringing it up before you. But that was a case, Mrs. Smales had, I'm probably going to mispronounce this, Ehlers-Danlos syndrome, I think is right, which restricts her mobility. And she needed to make adaptations to her home to accommodate her needs. So she needed to move the kitchen and the bedroom to accommodate her needs. And she had a leasehold for her flat, but the terms in the lease prevented alterations. And the Commission was undertaking work at that time in relation to housing and supported her in bringing a case against her landlord. And ultimately, the court ruled the landlord should have agreed to allow her to make the alteration works, which were reasonable in the light of her disability, and found that she was harassed by the landlord at a meeting held to consider the proposed alterations. So she was ultimately, Keris, I think, represented her, and she was successful. Oh no, you were against her. Sorry. Keris was unsuccessful, and the landlord had to allow her to make the adaptation.
So
that the wrong way round?
Could possibly be served on behalf of the landlord.
She did put forward a good case, though. And another case I just want to mention, some of you may have heard of, is the case of Pawley and First Group. So it's from 2017, but it's led on to a substantial amount of work in terms of transport for the Commission. This was a case, Mr. Pawley was a wheelchair user, and he was prevented from boarding a bus because a child in a pushchair was in the disabled space. So that case went to the Supreme Court, and the Commission supported him bringing that case, and the Supreme Court found that bus companies must do more to cater for the needs of wheelchair users, and that meant that the driver should have taken further steps to ask the non-wheelchair user to move, and bus companies should have clear policies in place and give training to drivers to help them remove any barriers which wheelchair users face. And as I've said, a key feature in terms of the Commission is follow-up work. So we now have one of our priority aims is transport, and we're following up on work at the moment in relation to that. In fact, we have a legal support project about transport, specifically disabled people and older people who face barriers in terms of accessing public transport. And the legal support project means that we don't just support strategic cases, we support any case that meets the criteria of the project that has merit. So the idea is for the Commission to build up expertise and to support any discrimination case that meets the criteria for that project. We also, in April 2020, have a new education project we're going to be launching, which relates to reasonable adjustments and for disabled pupils, and more will be published in that in the coming months. But I asked you to have a look. Again, it will be a legal support project, which means that as long as something meets the criteria for the project and has merit, we will support it. It doesn't need to be a strategic case. Moving swiftly on, because I know I've not got very long and I kept everyone else to 5 minutes, so I shouldn't talk for too long. Section 30, interventions. So the Commission has intervened in a number of cases to provide our expertise and support to discrimination and human rights cases. For example, there was the case of Carmichael and Rourke versus Secretary of State for Work and Pensions, which was a case involving the bedroom tax, where we intervened in the Supreme Court, supporting where the Supreme Court found that the failure to provide an exception to the regulation in relation to bedroom tax was unlawful, where there was a need for an overnight carer for a grandchild in the case of Rutherford, and Carmichael in the joint case where the claimant could not share a bedroom with her husband because of her disability. We were successful in explaining how the Equality Act related to those cases, the joint cases. And another example of where we intervened in a case is Davey and Oxfordshire County Council in 2017. That was a Court of Appeal case. Mr Davey was a severely disabled man who challenged the council's decision to cut his 24-hour care package. And he argued that that would have resulted in his team of care workers losing or deciding to leave their positions. And they'd been supporting him for over 20 years. He lost his appeal, but the Court of Appeal found that Oxfordshire County Council had acted lawfully in reducing his care package. We intervened to support him and put forward the Equality Act Equality Act aspects of his case. So The last point I wanted to bring up was the unique legal action and follow-up work the Commission undertakes. So one of the sections I mentioned was section 24, injunctions. So an example when we've used this is the Commission versus Wilson, where we brought an injunction in the county court against Mr Wilson, a landlord who was considered by some as the largest buy-to-let landlord in Britain. He owns hundreds of properties in Kent, and one of his requirements for potential tenants was no coloured people because of the curry smell at the end of the tenancy. The judge awarded us an injunction, meaning that he was not allowed to have letting criteria which stopped people renting his properties because of their race. Breach of that injunction is contempt of court, punishable by fine or imprisonment. And that's an example where an individual may have found it difficult to bring an injunction against him because it was a blanket policy applied to everyone, but where the Commission has unique powers to bring injunctions on a wider basis. And one of the other sections, the last section I just want to bring up is section 31, which is public sector equality duty assessment. It links on really to what David and Michael were talking about in terms of public sector equality duty. But the Commission has specific duties. We've only used this once, an example I can find. So in 2010, we carries out an assessment of the Treasury spending review, making fair financial decisions. And you can see the report on our website. We did both an initial report, follow-up reports, and a final report in 2016 in relation to the Treasury's spending review decisions and how they had implemented the public sector equality duty in relation to that. There is a follow-on to that. In that case, we didn't need to use it, but in section 32, we can bring a compliance notice if we believe through our assessment process the public body hasn't shown that they're complying with the public sector equality duty. In that case, they actually, after several reviews and advice from the Commission, they did comply sufficiently with the Equality Act, the public sector equality duty. But we do have a power to follow up on that. And again, it's circumstances where it may be difficult for whatever reason to bring a judicial review claim, but the Commission has unique powers to bring action and raise discrimination issues that can't be brought elsewhere. And just in terms of follow-up work, we recently had an external evaluation of our legal work completed by legal researchers from University College London. So in October last year, they carried out research for us about the impact of legal work that the Commission undertakes. And they reported that the clearest evidence the Commission's direct impact is organisational improvements in policies and practices. So our legal work has made organisations better understand their legal duties under the Equality Act 2010, deliver services in a more accessible fashion, revise recruitment, training and improve awareness-raising measures, rectifying outdated practices and promoting organisational procedures that comply with the relevant equality and human rights duties. And they confirmed that our legal interventions often added legitimacy to equality and human rights issues. We have particular international European legal resources and expertise, and our role as a neutral player is seen as a contributing factor to our success. They said that our work has influenced judges' decisions and shaped judicial reasoning on equality law and has put a stop to unlawful practices, transforming organisations for the better. And some of our landmark cases have clarified legal standards and contributed to broader social and cultural improvements. So that's, hopefully a resounding endorsement in terms of the legal work that the Commission does and the ways in which we could support you if you are bringing discrimination cases, or perhaps in using our unique powers where a case isn't appropriate for whatever reason. There are contact details which we'll circulate because we have everyone's email address from when you signed up for the event. And I'm going to stop talking there and allow Mona to get onto the question and answer session.